Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott briefing, OSHA's ETS, What Employers Need to Know. This webinar will be recorded. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's briefing will address the requirements of the new OSHA Emergency Temporary Standard. Today's presenters are FortneyScott attorneys David Fortney and Nita Beecher. I will now turn the program over to David Fortney to start our briefing.
Well, thanks so much, Dee. And it's great to be with everyone today. And Nita, it's wonderful to see you again. How are you?
Doing well. Thank you, David.
Yeah, both Nita and I have been living the dream, as they say, working on a lot on the OSHA ETS and related developments. And we've got a lot to share with you. We will try to pick up your questions, as Dee indicated in the introduction. Put them in the chat box, and we'll do our level best to just run those as we go through things. So, Nita, I think we should probably just dive right in, don't you?
I agree. Why don't you kick it off for us, David?
Okay, I'll be happy to. So let me just say a word on the next slide about who we are. I think most of you know. We have very many clients and friends on, but we, of course, are based in Washington, D.C. We are proud that we are a woman-owned law firm. Yes, I am a minority in the firm as a man, and proud of that. But we do focus exclusively on a wide range of workplace matters, and particularly a number of the federal agencies that regulate the workplace. And today we're going to be focusing, of course, on OSHA, as well as the new federal contractor obligations, and work through where things stand today and how to put those items together. Let me just mention briefly on the next slide that although Nita and I, of course, are lawyers, and for many of you, we do regularly provide legal advice, the purpose of the presentation today is to provide general information and updates. And of course, you should consult with your counsel, either corporate counsel or outside counsel as authorized, to ensure that you have specific advice to address your circumstances. So I think, Nita, we've given both the required introduction and so-called Miranda warning, and I think we can go on from there. So let's start with what we're going to cover. You want to jump in?
Sure. Our agenda today, basically, obviously, we're going to talk about the Emergency Temporary Standard that OSHA issued that became effective on the 5th. We're going to talk briefly about the differences between the federal contractor vaccine mandate and what the ETS provides, because we know many people are going to be covered by both. We're going to talk very briefly about the religious and medical exemptions and some recommendations around that, where the litigation stands on the ETS and also on the vaccine mandate. And then we're going to give you a couple of takeaways, and we're going to try to do that in about 55 minutes or so. And so, David, I think you need to get going.
Will do. All right. Well, let's jump right into it. So let's start, Nita, as you indicated, with the Emergency Temporary Standard, or ETS. And so as we jump into just a brief outline of that, this is, think of it as it's a regulation, and what is perhaps unusual is that it's a regulation that is currently in effect. So we didn't have that run up with notice and comment. We'll talk a little bit about that, but let's talk about what's on the books now. What is in the ETS, and these are the key requirements. Obviously, I think as everyone on this call has heard, it's 100 or more employees, and that means that any time while the standard's in effect, if your head count of your entire organization reaches 100, you're covered by the standard. Second, who gets counted? That's very important. We know how to count to 100, but who gets put into the group that we count? The answer is that it's all full and part-time employees. Those of you that have staffing agencies, and many of you worry about joint employer and do they get counted or not, this is one where I would like to acknowledge that they made it a little easier on us. They get counted for the staffing agency's headcount, not for your headcount, not the host employer. who hire the staffing agency. So it's just really think of them as your W-2 employees, full and part-time, gets counted. There are some exemptions because you start with anyone that has 100 or more employees, all workplaces covered, all employees are covered by the OSHA standard if you have 100 or more employees. Are there carve-outs? Yes, there are a few significant exemptions or carve-outs to the coverage. First, there is already an emergency temporary standard for the healthcare sector. It's on the books. It went on in June of this year. And therefore, if you are already subject to those obligations, you will not be subject to the new OSHA ETS that we're focusing on today. Second, and this is where a lot of people are still trying to understand how these dovetail together, but workplaces that are covered by the federal contractor obligations, those workplaces are not subject to the OSHA ETS. And we'll unpack that a little more as we go through, but that kind of introduces the concept. Which employees? So we figured out which employers, which workplaces, which employees. And again, these are important differences. People who work from home are not covered by the OSHA ETS. That's different than federal contractors, so I just want to make sure. The OSHA ETS does not apply, does not cover employees working from home. If the employee works individually, meaning they don't interface with other employees or with customers, they're not subject to it. Think about if you're driving in a car exclusively, or maybe a driver that only drives individually, you might not be covered. And if you work exclusively outside, a number of construction jobs, for example, may fit into that category, and those workers would fall outside even if other portions of the employer's operations are covered. Hey, Nita.
Another important thing to point out here, David, just so we don't forget it, is the fact that this ETS very firmly states that it overrides, it preempts any federal, state, or local laws that forbid vaccination. So they are taking preemption to the nth degree with the ETS.
Right, and that is, that's one of the points. We'll touch on that briefly in the litigation discussion, but it's OSHA's position that they enjoy very broad preemption. They have a statutory provision that provides for preemption, and as they say, we will see that is being actively sorted in the courts. Juanita, let's talk a little bit about what the deadlines are, because we've introduced the basic coverage components of the ETS. Let's talk a little bit about the deadlines.
So the first deadline, which is really important, obviously, was November the 5th, which was the date that the ETS was published in the Federal Register. And we've talked before that the ETS becomes effective immediately upon being published. So in this case, the ETS is in effect at this point in time. David will talk a little later on about the litigation and what that all means. The second important date is December the 6th, easy to remember because it's my husband's birthday. It is the date by which all of the compliance requirements need to be done except for testing those employees not fully vaccinated. And we've got a list for you of the major ones of those. And the final date at this point is January 4, which is going to be the date on which you start to roll out your testing requirement. But David, is that still the correct date based on what we saw yesterday on the federal contractor mandate?
Yeah, so I think those of you that have been following this closely and that we've been advising certainly are aware that there was a shift in dates based on this January 4th, a week or so ago, because contractors are told, hey, good news, it's no longer December 8th. We're going to move your vaccination mandate date out a few weeks. We're going to step it out so that the coordination occurs so that everyone has to come online on January 4th. And I think there was collectively a sigh of relief because, as Nita mentioned, many employers are both doing commercial work and would be subject to the ETS, those workplaces, employees, and then federal contract work. So you'd have these two requirements. At least they would go into effect on the same date. What we saw very late yesterday, and this is kind of breaking news, is the federal contractor deadline is going to now be extended again. It went from December 8 to January 4. What we have seen published is that it's going to be extended to January 18. January 18. So it's actually a 2-week extension beyond the January 4th. And we'll unpack that a little more about how that occurred, but it's going to be in a notice that's going to be put in the Federal Register next week. But what that means is that OSHA ETS compliance comes first, and then the contractor compliance in terms of vaccination requirements will come 2 weeks later on January 18th. So I think that's significant. Nita.
Yeah, so let's go to what do you have to have done by December 6th, and what do you have to have done by December the 4th? Now, we just put a few key items, and we're going to unpack all of these requirements in a minute. But on December the 6th, the kinds of things you need to have in place is your policy. You will have had to survey the vaccination status of your workforce. You need to collect proof of vaccination. You need to create a roster of your employees with their status. You need to provide your employees with paid time, and David, we're going to talk about what that means in a minute, up to 4 hours to become vaccinated, up to 2 days paid PTO or sick leave for employees to recover from side effects of the vaccine, training of employees, and ensure that vaccinated employees are going to wear masks in the workplace. Finally, the final step is going to be on January 4th. All your employees either have to be vaccinated or subject to testing every 7 days and masking. And so
Right.
Those are the biggies.
So I just want to pause on that before we jump off that slide. A lot of these things, many people have a general sense as to who's vaccinated. This really means that in the next basically 3 weeks, you've got a survey, you need to be collecting and determining who is or is not fully vaccinated. And let me just say, when we say vaccinated, what we mean is fully vaccinated, which means if you have a 2-shot regime, you have received the second vaccine, and the requisite 2-week period has passed since your last vaccination. If you're the 1-shot, the J&J, again, the 1-shot plus 2 weeks, that equals vaccinated, under these rules and in our discussion. The training of all employees. Obviously, many of you joining us today have very significant size workforces. It has to be done virtually, but some level of training and information, typically accompanying a push out of a policy, is to be done by this December deadline. Those are heavy lifts that I think many people have not really focused on, and I'm worried because the time period includes the intervening Thanksgiving holiday, and so I think attention to these obligations very promptly is in order if they're not already on your radar screen.
Well, let's unpack those a little bit, David, because I think we need to give people an idea of what each of these means. So in the next slide, the first one is that employers must establish, implement, and enforce one of 2 policies. Now, I put it one of 2 policies on these slides, but really the way that the regulation says that you should establish, implement, and enforce a mandatory vaccination policy, and that the idea of being able to test the employees, which I'll talk about in a minute, is actually just an exemption from that. So the hard push, David, in all of this ETS is that everybody should be vaccinated.
Right. And so I was just going to say, Nita, and that
go ahead.
Fundamental threshold question, right? Whether you're going to take the OSHA ETS and impose the mandate, and those of you that are federal contractors, as most of you are, that then means that you could largely align your OSHA compliance with your federal contractor compliance. And that's an option that many, although there is potential negative impact on the workforce, and OSHA was well aware of that. And that's why there's this second option, right?
Exactly. And so if you have that mandatory vaccination policy, you will have the same exemptions you would have as a federal contractor for medical or sincerely held religious beliefs, and we'll talk about that a little bit. So OSHA did provide employers, and it's employer choice, to allow all employees to either be vaccinated or to provide proof of testing and mask wearing. And again, you have the exemptions for medical or sincerely held religious beliefs. So ETS allows you to have a testing policy, David, for those employees who, for various reasons, do not wish to be vaccinated. And that testing doesn't have to be tied to religious beliefs or medical reasons, simply that people don't want.
A test out option, right? They can simply, I don't want to be vaccinated for whatever reason, good reason, but I just don't want to be vaccinated. Okay, have a test. But let me emphasize, Nita, this is the employer's option. This is the employer's choice. And counsel for companies that are listening today, please remember your client needs to make a choice. Do we want a vaccine mandate or do we want to let employees opt out? It's a threshold question and it drives everything you do at that point. All right.
So David, I think the next step on our list, if you go to the next slide, is how are employers supposed to determine that vaccine status?
Sure. So the regulation is very specific. Some would say prescriptive. We're not on the trust but verify. It's on the verify in very prescribed ways, and it requires you, the employer, to look at the vaccine document and to maintain proof of the vaccination status. So this is a little different. Those of you that have worked your way through the contractor, you didn't necessarily have to keep a record. You had to have a process for checking. OSHA is more prescriptive. So what we envision what most clients are doing is people are photographing a PDF copy of their vaccination card and doing that, or they're making reference, providing access to public databases, public state health agencies, other agencies that, depending on the state and the jurisdiction, where reliable records are provided, enabling you as the employer to confirm affirmatively and to maintain a copy of what the employee provides. Nita.
And David, just a quick list. I mean, they're the same list that we had for federal contractors. It's a record of the immunization from the healthcare provider, copy of your vaccine record card that we all keep in our purses, our wallets, medical records, immunization records from the public state or tribal immunization information system, other official documents, and those are all the preferred documents that you're supposed to collect.
Right. Now, it is recognized that there may be some circumstances, and clearly OSHA envisions that they will be limited, in which an individual says, I can't produce those sorts of highly reliable records that the regulation prescribes. In that instance alone, OSHA says that the employer may allow a verification, but it's a very specific verification. You need to use the form provided by OSHA. It requires a declaration subject to the penalties of perjury by the individual employee, describing what vaccination they have, describing why that they can't locate it, and stating to the best of their ability when they were vaccinated and so forth, so that you can, based on that verification, confirm that they are fully vaccinated and that you're able to treat them as being vaccinated.
David, there's one other point that I want to make. I know a number of employers went ahead and gathered data from their employees wanting to know who was vaccinated before the ETS came out. And OSHA has been kind enough to provide an exemption. So the exemption is if the employer has asked employees about vaccination status prior to the effective date of the ETS and retained records of the employee responses, then the employer does not have to go through and reevaluate vaccination status for fully vaccinated employees. And I know that some people simply had employees answer questions and upload it without asking for the documentation.
Right. So there's a grandfathering if you did things that didn't quite meet these more rigorous requirements. The document retention is as long as the ETS remains in effect, as long as this standard's in effect, you must keep these records obviously kept in separate and secure files. I think that drill is well understood. The big point there is this isn't the 30-year retention period that many of us feared and that we had indicated to OMB when they were looking at this, we thought would be deleterious to employers' interests. So that's at least some small positive on the record retention. All right. What about paid time? let's talk briefly about that, because OSHA's regulation also has two requirements that we are to provide paid time. The first is for receiving a vaccination. And the requirement is that you are required to pay for the actual time spent in getting the vaccination. It could be up to 4 hours, and some may have experienced you sometimes have to wait in line if you go to the local pharmacy, depending on where it's being administered. So that would all be, if you will, on the clock. That is compensable time, and it's for the actual time incurred, and so that requirement's there. Second, what about after you get the vaccination, that there are sometimes side effects, that you don't feel well for a day or two? My personal experience was it's about 24 hours, 36 hours. And I think most people have had similar feeling. Well, OSHA recognizes that and says that, again, the employer is required to provide paid time off. Now, note, I'm not saying compensable time. This is paid time off. And so up to 2 days of paid time off. And it can either be if you have a PTO policy and the person has the requisite time up to 2 days in their PTO bank, they can be required to draw it down. If you have a sick leave policy separate from other leave, they have to have at least the 2 days available in the sick leave bank. If they have exhausted all applicable leave, you now will have to provide them additional paid leave time for up to 2 days to recover from the side effects. So that's something I think most people, once they're aware of, it can be worked out, but it could be a gotcha if you're not aware of it. Nita.
One thing that I thought was helpful for employers is if somebody goes off their time, and on the weekends that they're not working, when they're not during work time, you do not have to pay them for that time. If they get it's only if they get the vaccine during working time that you actually have to provide pay.
Right. Now, remember, to the extent you're trying to incentivize individuals getting vaccinated, right. I think many employers are saying, look, we want to do this on paid time because we want people to be vaccinated. But you could structure it, you have that flexibility. All right. Well, let's talk about the testing option a little bit. Nita, you want to kick off on that?
Sure. So if you want to use the ETS's option to provide either vaccinate or test, it applies to both. So that this means that you have people who are unvaccinated, not fully vaccinated, or fully vaccinated employees who do not want to submit proof of vaccination status. And these are people, as we talked about earlier, who are working around other people or customers. So either coworkers or customers. So that's kind of your group. The testing and mask wearing is at the employer's discretion. You can use it on maybe you only want to use it some places and not others. That's up to you. But the employees must submit their test showing that they're negative no later than every 7 days. And if they do not, they'll be denied entrance and they won't be able to work. One part that they do allow is if someone has had COVID, they do not have to test for 90 days. And we'll talk a little bit about positive tests. So David, on the next slide, let's just kick over to what kinds of tests and some of the other things. I think the most important thing, and one we were really wondering about, is could they use basically the quickie tests, the antigen tests? And the answer is yes. You can use them, but you have to be observed by an employer representative or an authorized telehealth proctor. In other words, you can't just do it at home and say, oh, by the way, I tested negative. Right. And basically, so any authorized test by the FDA can be used for that. So here's the tricky part, David. Pay for time, pay for testing, pay for masking. ETS says no.
Right.
So,
which is kind of surprising and is different than most prescribed safety requirements, that the employer does bear those costs typically under OSHA standards and otherwise. So what is going on here? Well, the underlying philosophy is that you're trying to penalize is the wrong word, but you're trying to make it more burdensome, more difficult on the employee, particularly those who opt to go to testing. and just don't want to be vaccinated. Once again, we're incentivizing, we're rewarding vaccination, and we're putting more burden on those that aren't vaccinated. Now, we talked in great detail about who has to be paid for what when you're vaccinated, when you're recovering from being vaccinated. What about testing? Every week I've got to go get tested because I don't want to be vaccinated. Is that compensable time? Is it work done for the benefit of the employer? There's a very compelling argument that no, in that situation, for an employee who voluntarily says, I don't want to be vaccinated or I don't want to disclose, they are electing to be tested, and therefore that they potentially should not be on compensable time. That's an open issue. And we do expect from the conversations we've had with the Labor Department, senior policy officials, that additional guidance will be coming out in the very near future. A prediction from what we're hearing, the guidance is likely to reflect that testing time is not compensable. Note, before everyone says, oh, that's good, that really reduces our burden and cost, it would. State laws are often quite at odds with that conclusion. And on a wage hour law issue, the more protective state law will control. It will control. So the federal law is the floor, but if the state law requires payment, you would have to comply with the state wage and hour law, wage payment law. Similarly, those of you, of course, that have unions, check with your collective bargaining agreement and or consider bargaining. Nita.
Yeah, and you've got the same issue with paying for the test. We've had conversations with clients about, do they have to pay for the test? Is it already covered under other acts and so forth? So you need to really dig down in that and decide what works for you from that perspective.
Right. Now, I do think in this who pays and doesn't pay, I think it's different if for an employee who has to have an accommodation, medical or religious.
Correct.
Then the employee is not voluntarily. That is the only way they can comply. So in those circumstances, I think it is prudent that to approach that as it's compensable time for the testing, and you may also want to provide the test itself because that's the accommodation. Okay. But that's still to be further refined coming up. We anticipate further guidance on those issues in the next week or two. I do want to underscore one thing, because a lot of employers say, oh, I like the testing option because then my employees aren't going to quit. And I get that, because we have some clients that have had up to 10, 15, even 20% of employees that said, if you make me get vaccinated, I'm leaving.
Right.
So that's obviously a very serious concern. On the other hand, the testing, putting aside the cost of the testing, whether you bear it or the employee bears it, you have to deal with the record keeping every week. You have to update. You have to determine work eligibility every single week for every employee that's on the testing regime. And again, those that are not fully vaccinated, and we're going to talk about this a little more, you have to maintain the masking regime. So there's a lot of incentives for employers to not allow open throttle testing also, to go with the vaccine mandate. And again, it's structured that way by design.
So do you want to talk a little bit about the face covering requirement? They call them face coverings in the ETS.
Face coverings, yeah. We're showing we're so out of step, Nita, because 2 weeks ago we said masking, but now we're face covering. So so face coverings or masking is addressed. And I think the takeaway is that some of the more, I'll call it casual face coverings that often have been permitted or acknowledged, the gaiters, just pulling up the single level gaiters, throwing the bandana around, a single layer of cloth, that's out. They have to be, and there's a lot of technical detail under the CDC guidance as to what's required, but it's a multiple layer. Think of those at a minimum as the surgeon type medical masks that we've all seen, up to and including the 95s, K95s, and others. But the casual holding a tissue in front of your face or just a little one layer of cloth, that is not going to cut it. So although employers can require employees to provide their masks, you employers are required to make sure that the masks meet the requirements, the face covering requirements, and are sufficient. Nita, do you want to just touch on exceptions? Because there are a few exceptions.
Yeah, there are the usual exceptions. These were similar to the ones we talked about before. If you're in an office with basically an office with a door, you don't have to wear it. And these are for unvaccinated employees, unlike the federal unlike the federal vaccine mandate requirements, when you're eating and drinking or for safety reasons.
Right.
Interestingly, the employer is required to monitor this, David, and we'll talk a little bit later about some of the issues that may bring up as far as people knowing who's vaccinated and who's not.
Right, which is tricky. All right, well, let's talk a little bit about some of the notification requirements on this.
Next
Obviously,
slide.
we touched on this a little bit about the policies and so forth. But part of the training that we talked about by December 5th is that it's training the employees what they're to do if they do develop COVID symptoms, that they are to tell you, the employer, and that they must promptly tell you. So we don't want people coming to work either with COVID or with COVID-like symptoms, and we want that reported to us. There are certain obligations that you have as an employer in terms of promptly removing people, or employees from the workplace, and the circumstances under which, how long they have to be held out and when they can be returned. That's all spelled out. Largely, those of you that are familiar with the CDC guidance on this point, I don't think there's any new ground here. The difference is it's now effectively being codified as a regulatory requirement, and so there will be more strict adherence to it, and expectation of compliance. All right, and that deals with the notification, the removal, and the return. All right. Other information to the employee.
Yeah, and so let's go to the next slide. And, we're working our way down that list that we showed about what you've got to have done by December the 6th. And these are all things you've got to prepare and submit to your employees. Information on the ETS requirements and policies and procedures to implement it. A lot of this, David, OSHA's done a terrific job with all the supporting. They've got model policies for both types of approaches. They've got a lot of FAQs. They've got forms you can use, and these are all things. There is a CDC document which you need to provide to the employees, obviously, all to make them get vaccinated as quickly as possible. Information on retaliation and discrimination, because we expect that some people may tell on other people that they're not wearing their mask and they should, or they lied on their forms and that type of thing. And also information that if you lie on one of these forms saying you are in fact vaccinated when you're not, or you buy something off the internet that says you're vaccinated, then what can happen to you? You can go to jail potentially because you're lying on government documents and so forth.
So they're then so that's the training to employees. Employers, there are obligations that we have in terms of when certain instances, it isn't just totally passive or training employees. There are affirmative reporting, and again, this isn't unique to this standard. Other OSHA standards do contain these types of obligations, that if someone is seriously injured or the death in a workplace-related incident, that is what's called a reportable to OSHA. The way that's handled here, obviously, and these have to be work-related exposures.
Let's go to the next slide so we can talk about that, David. Okay. There you go.
Yeah, that's great. Yeah, thank you. The work exposures can sometimes be a little bit tricky because COVID, it's hard to tell when that occurs or not, but either fatalities very promptly within 8 hours of learning, no matter how long after. So if someone has contracted COVID and has been hospitalized and then dies, potentially weeks or longer in the future, it still potentially could be reportable. Then the more common, fortunately, still not very common, but if you have in-person hospitalizations that are workplace related, the employer must report that within 24 hours of learning that. Work-relatedness. Let me just touch on this very quickly because it's a little tricky. Certainly, if you start finding what I'd call a clustering, if multiple employees in a common work area begin experiencing COVID symptoms, and particularly if any of them suffer hospitalization, you likely at that point have an OSHA reportable situation, because there's always the debate about did they or did they not, is it workplace related?
Right.
But once you see multiples in a common workplace, then it potentially is workplace related. At a minimum, please confer with your counsel and make sure you get detailed legal advice. Do not make a mistake on whether it's reportable or not.
So David, let me just do the next slide about records availability, because this is a typical OSHA, and I know a lot of employers may not deal with OSHA all that much, but these are some of the things you're going to have available to your employees. First and foremost, if an employee comes to you and wants to see, he or someone with authority from him comes to you and wants to see their own documentation and testing results, you have to give that to them within the next business day, by the close of the next business day. And they can also ask to see the total number of fully vaccinated employees and total number of employees at the workplace. So this is, David, I hate to say this, a very plaintiff's counsel kind of piece of information.
Right.
But then, David, to OSHA, what is it that the employer has to be ready to provide and when?
Right. So those written plans that Nita talked about that you were to be developing and implementing, if OSHA knocks, they expect that within 4 hours of when they show up, you are to hand the plan over. Why so quickly? Because they want to make sure that you, in fact, have it in your top drawer. You cannot, in under 4 hours, create a plan that's going to pass muster for most people. And so it's the plan, the total COVID numbers, all that sort of record keeping that you are to have effectively contemporaneously been required. Within 4 hours, you turn that over. Additional record keeping, and they will be extensive. Every single thing required by this regulation, the OSHA inspector will say, turn it over by the next business day. The failure, even if you have the records, the failure to provide them timely is a violation, the way this regulation is written. So the records need to be accurate. They need to be contemporaneous. You need to be on top of this, because OSHA, I think, is going to be very focused on that.
Right.
It's outside. I just want to say one thing, Nita, as we move to
Sure.
the things. In terms of OSHA, there's a whole separate, outside the scope of today's discussion of OSHA enforcement. Violations, though, are punishable by civil penalties. And the civil penalties can be up to $1,360, say $1,400 per violation. So think of each employee, each item, it can be a violation, could be per day. It's not clear how they're going to calculate that. A willful violation allows for a multiplier of up to tenfold. So a single violation becomes, instead of 1,400, 14,000 times however many employees, however many violations. Let me further add, the pending Build Back Better and the budget resolutions include significant increases in the OSHA penalties. Whether they will be enacted or not remains to be seen. The increases are tenfold what's on the books. That means a simple violation becomes a $14,000, not $1,400 problem, and a willful violation for one employee one time is $140,000. That converts these cases to multi-million-dollar cases like that. So
wow,
this is something we will talk at a different day about what enforcement looks like. Today, we want to focus on and stay with compliance. It's very important for a whole host of reasons. All right.
So David, I want you to, let's let you sort of kick off one more slide. We want to talk about the differences, because so many of you have, and I know there's been a lot of confusion about the differences between what's required under 14042, or the federal contractor mandate, versus the ETS. And so, David, you want to kind of walk us through that?
Sure. I'll just hit the highlights, because we've actually summed up some of these, I think, as we've gone through. First, as we all know, and those in the federal contractor community, anyone who's working on or in connection with, very broadly defined, are working in a covered workplace, even if they're not working on or in connection with, if they simply work in one of those workplaces, is covered by the federal contractor vaccine mandate. No test out option, it's a vaccine mandate. And it does pick up those that are working from home or remotely, different than the ETS. They also, those workers are also, those employees, subject to the vaccine mandate. The only use of testing for the reason of the contractors is for the accommodation, medical and religion. Very limited use of testing. Additionally, even when you have everyone vaccinated, masking or face covering obligations are much more significant for federal contractor workplaces or covered employees. It requires that in any county where the level is significant or high, and this is, you go to the CDC website, I always think of it as orange or red. If you're in an orange or red county, even if your workplace is absolutely perfect, based on your location, your physical location, you must wear masks, face covers in the workplace. Notice social distancing is no longer part of the equation, face covers are. Nita, let me stop on that. Anything you want to add on those points?
No, I think we've got everything except we also talked about the new extended deadline for January 18, and we can talk about that a little bit more. But let's go on to EEOC. We did get a question about EEOC. So,
yeah. Well, that's perfect timing because we have a on it.
Yeah. So, for those who do the vaccine mandate aspects of this, there is an obligation, as we know, to go through and determine whether employees might be exempt under a religious belief, sincerely held religious belief, I should say, or under a medical reason. And so we have gotten quite a bit of guidance recently from EEOC around this. It is the most difficult one, I think, for most employers, David, is the religious accommodation. Under the ETS, it appears that even if you have a vaccine, you pick the vaccine mandate, you can still allow employees to test and be masked as an alternative to being vaccinated. And if you wanted to, you could simply use it for those purposes. And we're starting to get a sense, even under the federal contractor mandate, that testing is going to be an option for in a limited basis, because they don't see that that's if you use it on a limited basis, it appears that that's going to be a reasonable accommodation.
I'm just going to say, Nita, and the process for sorting out, particularly the religious accommodation, that has evolved because, let's face it, most employers have not had a lot of experience in addressing religious accommodation. Pretty significant experience under ADA medical accommodations. But for religion, and particularly now on sort of a large scale basis, many employers will find they're dealing with, the federal contractor guidance had started with a much more rigorous set of form that had a number of questions about probing the legitimacy and whether it was a bona fide religious view.
Correct.
That the federal form, federal contractor form, has largely, at least for the federal workforce, throttled back and now largely mirrors the EEOC's own form. And I think in terms of not violating either the EEOC Title VII requirements or federal contractor requirements, use of the EEOC form, which is what I call the more lenient approach, but easier to recognize religious beliefs to accommodate, is what most employers, I think, have shifted to and are currently following.
That's right. I think there was a lot of controversy a couple of weeks ago, David. There was I think a kerfluffle of criticism about the model federal employee form, and EEOC then released their own form, which is broader. But David, there's one very odd thing about the EEOC guidance, which says that because under Hardison, your obligations to accommodate are much more limited. You only have to, if there's a de minimis burden or cost to you, the employer, you do not have to accommodate. The EEOC said that if you get too many, you only have to accommodate some people. You don't have to accommodate everybody. And we found that to be interesting.
Right, because if you lose too many people or they can't work as you need them to,
correct,
e.g. vaccinated, then you no longer have to accommodate. You are allowed to maintain your workplace operation. So I think the other thing to point out, the EEOC has recognized, and we have clients that have seen a good bit of this, what I call the my body, my temple response, or I don't want anyone telling me what to do, and a host of other responses that reflect, I'll call it individual freedom, social views, sometimes political views. The EEOC has said that does not constitute a bona fide religious belief that needs to be accommodated. And we've found a significant number of our clients have been seeing their workforce responses that include just those types of responses, and pretty uniformly, our clients have said, "I'm sorry, that's wonderful that that's how you feel. That is not going to be accommodated. You either need to get vaccinated or move forward in a different way."
Yeah.
All right.
So, but clearly under the ETS, testing is an option. The other option which you have under the ETS, David, is people, if you have this availability for the job, is people could work from home because there is not an ETS obligation to be vaccinated.
Correct.
Well, David, I think we probably want to talk a little bit next about where the litigation on everything is.
Yeah, let's just touch on this briefly. I mean, honestly, I would have had to have worked in overdrive to create a law school exam that is overwhelming and complex as the flurry of litigation that we have nationwide. I honestly don't know the number of lawsuits that we have pending. There are many. The one that has received perhaps the most attention recently was on November 6th. That was on Saturday. So let's go back. The OSHA ETS is published on Thursday the 4th. On Friday the 5th, it's published in the Federal Register. Litigation is filed late in the day Friday. By Saturday afternoon, November 6th, the U.S. Court of Appeals for the Fifth Circuit, 3-judge panel, issues a stay. It doesn't enjoin it, but it issues a stay on enforcement of it, pending further briefing. The briefing has occurred in rapid fire succession this week, and as we at least present today, November 11, we have not yet had a ruling by the Fifth Circuit on that. There also are additional cases being filed, and there is a process under the Federal Rules of Civil Procedure when there are multiple cases relating to the same issue in multiple courts. There is actually what's called a lottery, and it's just that, a random selection of one court, and all the cases get assigned and consolidated and adjudicated by one court. So whether it's going to be the Fifth Circuit or one of the other circuits remains to be seen. We don't know which court is going to have the final word. I actually predict, I think the Supreme Court will have the final word on some of these issues. Nita,
I think that's right, David.
On that November 9 ruling that we just got from the district court?
Yes, there were a number of military and probably federal employees and employees of federal contractors who work in and around Washington. They filed a lawsuit to block the federal contractor requirements and also for the active duty employees. And in that case, basically the district court said refused to block vaccine mandates for either federal contractors or military service members. And just since it happens to be Veterans Day, and my husband is a Vietnam era veteran, although he wasn't actually in Vietnam, nevertheless, he talks about the rows of vaccines that they had to get when they're in the military, and this is yet just another one. And I think that is what really kills many of the arguments from active duty military.
Notwithstanding that the Fifth Circuit expressed some open skepticism on the OSHA ETS, I do think the odds of the federal contractor obligations being judicially sustained are much greater. The OSHA ETS, there are concerns that some judges may find to be very appealing. If it's a grave danger, why did it take you 4 or 5 months following the president's announcement in September to implement the requirements? Why is it different for employers with 100 employees versus those with 92 employees, or some number less than 100? What's the reason for that, et cetera? So whether that ends up being the death knell or not of the ETS remains to be seen. I will say one important takeaway. The litigation is sufficiently uncertain and clouded. I would not rely on the litigation to stop efforts on compliance. That I think would not.
I think that's right.
Yeah.
One thing right before we jump to our last, yes, go ahead, Dave.
I want to talk about state law because a lot of people
go right ahead.
Are very focused on, and that is, as we know, whether it's the governor of Texas with executive orders, whether it's the state of Montana with broad state laws saying you can't ask vaccine status for any reason, whether it's for work or to go into a store, or the great state of Florida, which is prohibiting face covers and other restrictions. Well, what's the impact of these new federal requirements, the OSHA regulation and the federal contractor obligations on those state laws. OSHA, of course, in its standard says we intend to broadly preempt. Those cases, again, are just starting to roll through the system. As a general principle, though, to the extent that states try to regulate and impede the federal government's broad procurement authority, those laws will be ruled to be preemptive, assuming that existing case law is followed. Similarly, with OSHA, to the extent that states enact specific health and safety laws that are at odds with, that conflict with these requirements, those laws will be found to be preempted. That is state law requirement. In terms of the broader laws or whether additional obligations can be imposed, those are still being sorted through. Two other points quickly. Some clients, and I'll take Governor Abbott's Texas executive order, which has kind of a personal conscience objection in addition to a purely religious exemption. We have some clients that are saying, okay, at the moment, this executive order is in effect, I'm supposed to comply with it. So they're granting a conditional, a broader exemption, noting that in the event that the federal obligations kick in, they reserve the right to revisit and to assess under then governing federal standards, number one. Let's see, number two, oh, I've lost number two. I'll come back to number two. Okay.
Well, the ETS is going to apply to a lot of employers who are actually federal contractors, and because of the delay in the federal contractor standard and the way that the contract clauses roll out, employers need to make sure that they are also in compliance with the ETS if there is a period of time between the two where one's in effect and one is not. Don't you think, David?
I do. And the extension of the January 18th deadline that we talked about before for contractors starts to raise that issue, at least for a transition period.
Correct.
And the question is, can I rely, if I have a contract clause put in and I'm now under the federal contractor obligations, can I go ahead and implement effective immediately and avoid having to have a period of time where I'm not covered by the federal contractor? And I think the answer is generally yes, but again, and that, so I think but that's where the litigation is. It's a bit of a muddle. I do think that the state laws, I will say overall, the vaccination mandates have generally been recognized and affirmed by the courts in a very broad range of areas. So that tends to be, if I had to say that there's an overall flow, the decisions are flowing pro-mandate, and some options or recognition is given to some of these protected rights, which is why the option that if employers give the option to test out, that lessens the challenge on the OSHA standard. Okay.
Yeah, and if they allow them people to test on the religious, or if they're covered by an exemption as well. All right, David, are we ready to roll this our thoughts for employer takeaways?
Yeah, I think we should start with that, and let's talk a little bit, because a lot of material. So I think a lot of people at times like, okay, great, what am I supposed to do now? Because there's a lot, and so this is your takeaway, if you will, or what we would suggest as being, this is how we would prioritize in addressing these issues. So Nita, why don't you do the first one?
Well, number one, I mean, by December the 6th, unless something happens to derail the ETS, you really have got to communicate with your workforce. You got to have your policies in place. You've got to do all the things the ETS requires and roll those out to your employees. And so I think that's the number one thing that has to be done. I think do the training of your employees as to what they have to report, and decide how you're going to do some of the things that are laid out in the, and that leads to the next topic. Vaccination and testing protocols.
Vaccination and testing protocols, and this is a really big topic. And what we found is that once people, and I might add, most of these to-dos are cross-sectional. That is, they're a multidiscipline exercise for most organizations. And by that I mean it's health and safety, it's legal, it's compliance, it's HR, labor relations, and they're depending on your particular organization, there may be other disciplines that are part of that. It's your managers and supervisors, because although you have a broad educational obligation, they need to understand how they're to operate, how employees are going to be coming in, and that needs to be thought through fully. So, this surveying we touched on before, but conducting a meaningful survey, when we say determine which employees must be vaccinated, that means that you've looked now at the vaccination documents or
Correct.
the attestation if you're under the OSHA ETS and sorting through that. And that means it's kind of like looking at I-9 documents. You need to take a look, and you need to look responsibly. It can't just be a check the box, you turn something in. So some level of who's going to look at that, what the training is, making sure they know what they're looking for and understand what they're looking at is part of that. Mina, do you want to talk about the matrix problem?
Sure. And I think you've got to figure out, as David was just talking about a minute ago, how is this going to roll out? When is do you have a federal contractor obligation? Do you have a ETS obligation? When is that going to occur? And in the interim, before those go into effect, what are your state and local requirements around masking or vaccination or so forth? And all of those need to be done in a matrix, and not just for that, David, but also we're talking about protocols, but also you need to know, what are you going to pay for? For the vaccination periods of time, how are you going to pay for that? I know some of that's going to be tricky. And how are you going to determine, you've got to determine whether you're going to pay for the testing and all of that, and who's going to be responsible for those things.
I also think on this state and local law, because it's such a fluid situation, whatever your applicable states or your applicable jurisdictions, you have got to stay on top of that. And I mean, kind of almost a daily check-in. Because these situations are happening extremely quickly, with some of the governors exercising executive order, so you don't have the normal state legislative process. Many of you have very robust trade associations or other efforts that are underway, but paying attention to that is more important than ever on that. The verification process, we've talked about that. The ETS really puts a premium on that, understanding that, the record keeping. Again, many in your organization, you may have the health and safety people that control one part of certain types of workplace operations. Remember, this applies to all of your employees. So, and your typical health and safety team may not have the bandwidth, and more often than not, it's human resources and/or compliance that will have to take this on. But having that sorted out, doing the one touch, so we can get the records, we get the right records, we do the right process, we have a good workflow, and that we're maintaining them in the appropriate way. The front end architecture, that is at a minimum a role, lawyers, for you involved to make sure that's being done so that the results are sound and you don't have to redo it. So we want it done once, we want it done thoughtfully, and the planning on that is very, very important.
And we've talked a little bit about the testing, whether it's compensable. David went through that already. But I think the whole process for testing, and to the extent you're going to allow it, how are you going to do that? Because as the question someone asked, if you use it as an accommodation, my reading of the requirement is they still have to test every 7 days. Just, that's one of the possibilities. And so you're going to have to figure out how that's going to happen and who's going to do that.
And I want to emphasize, I think there's a difference, at least under federal law, in compensability that is for time and testing. If it's an accommodation, I think it likely is compensable under federal law, the FLSA. And if it's done because the employee is opting to be tested in lieu of being vaccinated or disclosing vaccination status, different. You may not have to. You may want to, but all the pros and cons. And I would add in there, collective bargaining, all that. Talked to a very large defense contractor yesterday. He was involved, he told me, in 23 effects bargaining undertakings right now. 23 different unions, and they're engaged in effects bargaining over these issues. And the company needs to get everyone on a uniform result. And needless to say, not all the unions were seeing it the same way. So that's a challenge.
Yeah, I can see that.
But you need to allow time for that to occur. And this stuff always takes more time than you can imagine.
I think the last thing, just quickly, David, though, is the accommodation process. you got to get that set up and going, because employers are spending. I think we saw a very large federal contractor has got, was it 20,000 requests for accommodation, in the workforce?
Yeah. There were some published reports to that effect. And certainly many of you hopefully haven't seen that number, but many are seeing minimal dozens and very common hundreds of religious accommodation. Yes. And many clients are saying, look, we're finding roughly 30-40% are clearly bona fide on the face. 30-40% clearly aren't. They're my temple, my body type thing. Others are kind of a jump ball. Remember, best practice is for those that appear not to be bona fide, you communicate, you have a little bit of an interactive process. So you do give the employee, look, we think that this isn't sufficient. These are the reasons we have concern. That takes time to answer and respond and engage with those employees. Final thing, we've had a number of clients, and Nita, you work and have presented very effectively with Tyson Foods, who's detailed the efforts they've made to secure voluntary, very high level of vaccinations.
Right.
And it's taken a lot of one-on-one efforts with employees who had reluctance. I call it reluctance, and working on educating and informing. So, but they got there. They largely got there.
Well,
all right. Well, final thing.
So, David, I think we've ended.
We're right on the mark. Yeah. Just resources. We're not going to go through these. The deck is available. Contact us if you'd like it. There are a lot of resources here. This is a good cheat sheet, I hope, for all of you. Check out the podcast. I do want to give a shout out to that. We do them regularly. We've covered a lot of the issues, particularly on the exemption issues. We have a great podcast with our colleague Leslie Silverman, the former vice chair of the EEOC, getting into this religious exemption. And we've unpacked the most recent EEOC guidance also in a podcast. And we've dealt with a lot of the other issues also in podcasts. So if you like that format for information, please check it out on the link is provided there. Final thought, Nita?
Get ready, because it's coming.
It's coming. I agree. I want to thank everyone for joining us, and Nita, I want to thank you particularly. It's always a pleasure, and we'll let it go there. Everyone enjoy. Be safe.
We would like to thank you for joining us. You will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through this survey. Thank you in advance for completing the survey. And of course, if you would like a copy of the slides, please email to info@FortneyScott.com. Again, please subscribe and listen to our new DC Insider Employer Update podcast, which you can find on FortneyScott.com or anywhere you listen to podcasts. Thank you.